everyone that is here because you've been to events in the past. Tonight we're going to be talking about California's new privacy law, which is pretty exciting. But a little background on the Midwest Cybersecurity Alliance. We are a group of lawyers, IT professionals, risk managers, people in the PR space. And what we try to do is focus on issues from a multidisciplinary perspective. So tonight, our focus is about privacy and what is reasonable security under the law, and we try to talk about it from a technical perspective and a legal perspective in every single meeting, and we host meetings every other month. And so on that note, before we get started, I want to talk about some of our next meetings. The next meeting for the Midwest Cybersecurity Alliance here is November 13th. CyberArk is going to host that. We're going to be talking about identity management. Then the meeting after that is going to be January 16th, and that's going to be on blockchain, and we're doing that with Sikich in the back. And then I think the meeting after that, we're going to try to do something with the Democratic National Convention, talking about what are we doing as a community with regard to cybersecurity and what businesses are doing and things like that. But we don't have that set yet, but that will be in the spring. If anybody has any other ideas or topics that you'd like to cover, please approach me or Ron Williamson from the medical college back there. Ron also has a microphone, so people can go to him with questions. So now I want to go around the room a little bit and talk about other events in town. We are attending the International Association of Privacy Professionals meeting out in Vegas. That's both privacy and security professionals. We're going to be talking a lot about the CCPA in the next couple weeks. I know that Syslogic is doing a cybersecurity summit. And Paul, where are you? If you want to say a few words about that, I know you put some stuff out on the table.
Thank you, Jen. So good evening, everyone. On October 28th, please save the date. It is Syslogic's second annual cybersecurity summit. We do it in partnership with MSOE. It is a bit of an event within the events because not only are we going to have some really compelling speakers and a panel and keynotes, but we're also going to have a number of security organizations participate. So there's an opportunity to meet those organizations. So ISSA, ISACA, of course, the Midwest Cybersecurity Alliance, HIPAA collaboration. So please save the date, October 28th. There are flyers out on the tables. Grab them. It's a free event, and it's also being held at the Dierks Hall, the NVIDIA Auditorium, which is grand opening tomorrow at MSOE.
Great. Yeah, I heard about that opening. There's others that have done that opening at MSOE tomorrow. I think that starts at 1, right? Yeah, I've heard about that event as well. Some other things, Terry and I we did the DACRA, which is the CIS framework about duty of care assessment framework. And Terry and I talked about that, I think, last year about this time. We're also presenting at the American Health Lawyers Association in Chicago in the fall about that, and also the Healthcare Academy as well. Does anybody else have any other local events they'd want to share before we get started?
A little bit longer distance, MCSA is going to be presenting next week at Secure World. We're going to be doing some discussions, roundtable discussions on cybersecurity jobs and minorities within the cyber environment, cyber arena. So look forward to getting some of that information out to people if you'd like to take a look at that.
Thanks, Ron. And Ron, you're speaking at that. Did you have something?
Real quick, our next meeting, will it still be up here or is it going to be changed to the modeling?
Well, it's either, we'll put directions. We are actually remodeling all of this space, so it's ready for next summer with everyone descending upon our city. I'm not sure if it'll be up here, it'll be down on the ground floor, but the instructions will be there. So I just wanted to point out, we offer both CLE credits for lawyers and CPE credits for technology individuals, which is out on the front table. So make sure you sign up so you get credits for actually attending the event tonight. This is our website, the Midwest Cybersecurity Alliance. You can go onto the website. All the materials from all of our past meetings are available if you sign up. So here's our website information. I want to point out, and you guys are aware, that we have a state data breach notification chart. This is available for free. You can just Google Foley's 50 state data breach chart. We update it quarterly. And really every state has a law. You just click on the state and then it shows all the different requirements under the laws. But we update it frequently. There's some examples out at the table. But the reason why we talk about this at every meeting is because obviously these laws are changing. But what's interesting about it is that this is where we're going with privacy laws. And so tonight, this is the start of the privacy law chart, unless we have a federal legislation. And I'm going to dive into that in a few minutes. But before we do that, I wanted to thank HALOC, who's co-sponsoring with us tonight. I'm sure you've met Terry. He's on the board. And he's going to be talking about reasonable security. But I just want to spend a few moments about how important the CCPA is. So who knows about GDPR? Whose organization has to comply with GDPR? Okay, so GDPR is the EU's version of a data privacy law, and this came out last year. Really changed the landscape. I mean, before GDPR, there was the EU Data Protection Directive that had been around for years. I would say that a lot of people didn't follow that law necessarily, didn't have the same types of penalties. Well, when GDPR came out last year and US companies had to comply, in particular with consumer rights, it really changed the privacy landscape in the United States. And so now we see California being the first state that has issued a privacy law. In addition to California law, we wanted to just point out a couple of things. NIST has a preliminary draft of a privacy framework that's up here if you want to take a look at it. Comments are due on the NIST framework by October 24th. So NIST is coming out with some advice. It's a risk management framework. I don't know if you saw, but IEC also has a privacy standards that they're coming out with, which is very important. And just yesterday, I think it was yesterday, the day before, I would say a dozen or more CEOs asked Congress to develop a national privacy legislative framework, and they proposed a framework which is pretty similar to DACRA, which Terry will talk about later. But in other words, we don't have one omnibus privacy law in the United States. We don't generally offer consumers rights to access or deletion of their data unless you're in particular industries, for example, the healthcare industry. So this is huge landmark change. And I will tell you that 20 some years ago, I lived in the Netherlands. I came back, I wrote my law journal on the EU privacy directive, comparing it to HIPAA, saying we needed this framework. And my friend over here is laughing, as I'm sure Jennifer is. And I will tell you, my law professor said, that's not relevant. We are not going to publish that article. So I will tell you every single day, this is what I do for a living today. But what's interesting is when we go through this law, don't think about it just as a company, which most of you all are from companies that have to implement. Sometimes you think of these as burdensome requirements. I mean, also think about it as a consumer. There is so much data usage and secondary uses of your data, let me just tell you, because we do this for a living, that is out there. And I mean, you as an individual want to know what's happening with your data. It's becoming more of a fundamental right in the United States. And we'll see. California is going to be the first law. We think a lot of other states are obviously in the process to adopt unless we get a federal legislation. So I just want to give you a little bit of a backdrop before we jump into the legal requirements. So I am Jen Rathron. I'm a partner here in the Milwaukee office at Foley and Lardner. This is Jennifer Hennessy. She's in our Madison office. She's a senior counsel. We've worked together for years. Terry, I'll let you introduce yourself.
Terry Krasinski with HALOC, and years in the room. This is from Beaver Creek in March of this year. So
I thought this was from the bonfire.
Rotator cuff surgery. So if we talk later on, you'll have to fist pump. Don't try to shake my hand.
Don't shake his hand, he'll cry. So, getting started, what are we going to talk about tonight? So we are going to do a pretty quick overview, a lot of sections. We're going to do an overview of the law. What does it cover? Specifically, consumer rights. Consumer rights are the hard piece. How are you going to implement consumer rights to access, deletion, et cetera? Today, we got lots of pending amendments on the CCPA. In other words, the bill was passed. We'll talk about it, but there's lots of changes that are coming forth. Then we're going to talk about penalties, the potential for litigation, and then at the end, we're going to give you really practical advice about how to comply with the CCPA. And Terry's going to focus on the security provisions of that. So getting started, what is the CCPA? It's the California Consumer Privacy Act. And essentially it gives consumers rights to access and control their information. And it doesn't, which Jennifer will get into detail, it doesn't really just apply to California companies. Essentially, if you're interacting with California residents doing business, then you'll have to comply with that. Many clients that mentioned out in the room that you have to comply with GDPR, it's similar to GDPR, but it has its differences. And we'll point that out as we go. I do think that overall, if your organization has to comply with GDPR, you're in a better position because you understand consumer rights, how you're going to handle these requests. You have a higher, I think, overall understanding of privacy frameworks, but you're still not there yet. So don't think if you're just in compliance with GDPR, you're going to be in compliance with the CCPA. It's effective this January 1st. However, the Attorney General has said they're not going to implement or enforce penalties until July this summer. More amendments are expected. Jennifer's going to cover those at the end of our session. And also the Attorney General is supposed to implement some guidance as well. So please be on the lookout for those pieces. So at a high level, what are we going to cover today? Well, you have to implement reasonable security measures. And what is that? Terry's going to focus on that. You're going to have to update your privacy notice on your website. You may have updated for GDPR, well, you're going to have to update it again for CCPA. We're going to talk about consumers' rights to access, their rights to deletion. Consumers have the right to opt out of sale of information because we all know what are consumers mostly concerned about. They're concerned about the sale of their information. There are some very murky and gray areas about how you cannot discriminate against consumers if they won't opt into the sale of their data. But there are certain financial incentives you can give. This really goes around loyalty and rewards programs. There's guidance just frankly issued a couple hours ago on those pieces. So if you do have rewards and loyalty programs, we'll have to discuss that in more detail. And then we're going to talk about the contractual requirements that you have to pass through to your service providers. So now I'm going to turn over Jennifer just to get on the scope of the CCPA.
Sure. Thank you. So you're probably wondering, who does the CCPA apply to? As Jen said, it's not necessarily just a business physically located in California. So there's really 5 pieces of the definition of who the CCPA applies to. So first, for-profit businesses. Second, that do business in California. Doing business is not defined in the CCPA, go figure. So you have to look at case law that's relevant from other circumstances to figure out when an organization is quote unquote doing business in California. You have to collect consumers' personal information and you have to determine the purposes and means of that processing. And then the 5th prong is that you fit into one of these 3 categories. So the most common one is probably going to be annual gross revenues of $25 million or more. If you buy or sell consumers' personal information, you might fit into the 1st or 3rd category up here, where you're buying and selling personal information of 50,000 or more California consumers' information, or 50% or more of your annual revenues come from buying or selling the personal information of consumers. So if you fit into that description, then you're going to be governed under the CCPA as a business. So just to shorten this up here, if you're wondering if something is personal information, it probably is. Everything is personal information. So we have some examples up here. This is not even all inclusive. It's really anything that relates to, describes, is capable of being associated with, or could reasonably be linked to a particular consumer. So obviously names, addresses, phone numbers, email addresses. It includes things like location data, IP addresses, things like that. So very broad definition of personal information in the CCPA. So we're going to spend a second on this slide, and apologies for the mess of words that are up here, but because we're all trying to figure out how to comply with this law, we really tried to make this slide deck as detailed as possible for you to use as you're working with it going forward. So we tried to really provide a description of both the exempt entities and the excluded data. So certain types of entities are excluded from CCPA, and then certain types of data are excluded from CCPA. So nonprofit entities that are not controlled by and don't share common branding with a business, again, a business fitting into that previous slide that I discussed. So if you're a nonprofit entity that's not controlled by and you don't share common branding with a business, you're not going to be regulated by the CCPA. If you're a provider of healthcare governed by California's CMIA, or you're a HIPAA covered entity governed by HIPAA clearly, then you're not going to be covered by CCPA to the extent that the healthcare provider or the HIPAA covered entity maintains patient information in the same manner that you're required to maintain medical information or PHI under California's CMIA or HIPAA. So if you're in the healthcare space as a provider or a health plan, then you might have some exclusion from CCPA, so you want to pay attention to that. There's also a number of types of data that are excluded from the CCPA. So PHI collected by a HIPAA covered entity or a HIPAA business associate is excluded from the CCPA. Again, note that it's only that type of data. It's not going to be the whole organization. It's only going to be that PHI or these other types of data that I talk through here.
And it's weird. So most laws just exempt entities
Yeah.
are exempt. I mean, here it's like it exempts entities, it exempts information, it exempts certain purposes. So you really have to dive into these is the point.
And a lot of the questions we've been getting from clients are, is this type of data that we hold by this type of our, company exempt from CCPA? And it really is a detailed analysis of looking at the type of organization and the type of data to see if you're exempt.
And some data may be exempt, but others may not.
Yeah, it's a nice little puzzle. Clinical trial data is exempt or excluded from the CCPA. Information collected, processed, sold, or disclosed pursuant to Gramm-Leach-Bliley or the California equivalent of that law, or the Driver's Privacy Protection Act of 1994 are excluded from the CCPA. De-identified or aggregate consumer information, both of which are defined terms in CCPA, are excluded from CCPA. And there's an exception for consumer reporting agency information in some circumstances. And I'm not going to go into a lot of detail on that right now because there's actually a proposal pending to amend this exception and potentially even broaden it. And again, it involves the buying or selling of information from a consumer reporting agency pursuant to the Fair Credit Reporting Act. So we're going to spend the next couple slides talking about service providers and third parties. So we have three types of organizations that we really see discussed in the CCPA. We have businesses that we talked about earlier. We have service providers, which is what we're going to talk about on this slide. And a service provider, importantly, enters into a written contract with a business to use or disclose information for a business purpose to a business. So that's very generally speaking what a service provider is. And then anyone else is a third party. So those are really the types of entities we're talking about under CCPA. So a service provider is a for-profit legal entity that processes personal information on behalf of a business and which the business enters into a written contract with the service provider. And I keep emphasizing written contract because if you don't have a written contract with an entity providing services to you, they're not going to be your service provider under CCPA. The contract also has to have specific terms. So it has to prohibit that service provider from selling the personal information, and it has to prohibit them from retaining, using, or disclosing it outside their direct business relationship with you as the business to provide services to you. And then there has to be a certification that the service provider understands these obligations and will comply with them. So a third party is really anyone else, just to be honest. So if there's no written contract, they're going to be a third party. If the contract doesn't have the terms that I just discussed or the certification, they're going to be a third party. And we have this written a couple different ways on a couple different slides just to emphasize the point. So I'm not going to read these all out loud to you. But again, that's the general difference between a service provider and a third party. And I like this diagram right here. I think this kind of helps to break it down. So again, no written contract. You're a third party. You're not a service provider. consumers cannot opt out of disclosures of their personal information to a service provider. So that's why it's important. So if you have a service provider, a consumer cannot opt out of the disclosure to your service provider. You need them to provide a service to you. Consumers can't opt out of that disclosure. They can opt out of disclosures to third parties. That's an important difference. Businesses have to direct their service providers to delete a consumer's personal information upon receipt of a verifiable request, which Jen's going to go into a lot more detail on that. But again, that's an important distinction between the two. And perhaps more importantly, businesses are generally in italics up there, insulated from liability for violations of the CCPA committed by service providers, but not necessarily third parties. So you want to put these appropriate contracts in place with your service providers for a number of reasons, but most important being that potential insulation from liability. If you entered into the correct contract with your service provider and you didn't have a reason to believe that they would violate CCPA, you're going to be insulated from some liability there.
Except when you make them a service provider, then you are liable for data breaches and other things. So, I mean, it's really thinking through, what is this entity that we're working with? Are they really doing a service for us? Are they really performing something on our behalf? Or are we just in an ecosystem together, just sharing data in order to provide a service on behalf of a consumer? But it is strategically, you have to think through what this entity is.
Yep.
All right, so this is some fun stuff. Consumer rights, this is what I mentioned earlier. So think about it not just as how would your company comply with these consumer rights, but you as a consumer realize these rights are out here. So what we're going to talk about is the right to be informed, which is really about what do companies have to provide in their privacy notice. Then we're going to talk about the rights to get access to data and to have portability of data. Rights to delete data, what rights you have to object to data being sold, and there's some nuances when it comes to minors, and the right to non-discrimination. So starting out is privacy notices. Almost all companies, especially larger ones, you have a privacy notice on your website. So, are you going to update that? Well, you're going to have to. Do you update your whole notice? Do you apply all of these provisions across the board to all of your consumers? Or are you going to do a California addendum? It just varies, by company. But these are the things here that you need to include. And really, you have to include, most importantly, the types of personal information collected, sold, and disclosed over the past 12 months. You got to think about where are the sources of information? Where is that coming from? Note on the third point, the categories of third parties that you're disclosing information to. That's another thing to think about. If you're disclosing information to service providers, you don't have to list it here. So what is the difference between service providers versus third parties? What are purposes? What are that you're using the data for? What are consumer rights? How do consumers contact you in order to afford these rights? Technology-wise, you're going to need to do a link and do a do not sell button. Now, if you're not selling any data, this is not going to apply to you, but if you are selling data, you're going to have to figure out, technically speaking, how are you going to implement that do not sell button? And you're going to have to talk about any sort of financial incentives, if you do have those, for providing data. But in the end, what companies really are doing is they're taking their policies. I know if you just updated them from GDPR, here we go again. But this fall, you're going to have to look at your privacy notices and do some updates, either to the entire notice or do a California-specific addendum. So here, we're not going to go into detail, but obviously if you change your collection activities with different types of PI you collect or any sort of other different uses and disclosures, you're going to have to update your privacy notice. That's only good for data collected within that time period that you had the notice up. So now, this is a really hot topic. So before we get into the individual consumer rights, one of the differences between CCPA and GDPR is that you have to verify that you have the right person. So there's been a lot of discussion is, what if you have these, potential class action plaintiffs out there that are going around to see if they can just get information from your company? Because if you don't verify someone appropriately and you give them access to data, then that's a data breach, which we'll talk about later on. There's class action penalties associated with that. So companies are trying to figure out, how are we going to verify who this person is? Do we have the capabilities internally to verify that? Are we going to go to a third-party resource? I will tell you there are many companies that are in the space that are providing technical solutions to verifying consumer requests, along with providing access and deletion. In fact, when I go to the conference, I mentioned IAPP in a few weeks. Jennifer will be there as well. We're going to gather a bunch of materials. And so if anybody wants to find out some information about third-party resources, we'll have all that for you. But you got to think about, how do we verify who someone is that's making the request? And you basically, we're going to get some more guidance, we think, from the California Attorney General on this piece, but in the interim, you got to prepare. So think about that from a technical perspective, but also, generally speaking, you're going to have 45 days to respond. That seems like a long period of time, but if you had to go into your company today, would you be able to pull all of the PI related to, say, me, Jen Rathburn, within 45 days? How do you pull that all together? Have you done a data map? Do you know where all your data lies? 45 days is actually short. You could potentially extend that time to 90 days, taking into consideration the complexity. What we've been doing with organizations is really doing playbooks, sitting down and thinking about who in our organization is going to respond and handle all these consumer requests. So we've done a lot of work for clients on policies and procedures, playbooks, forms, setting forth internally how you're going to deal with this. So you got 45 days, you may have 90 days. You want to start thinking about, how are we going to communicate with consumers about these requests? What types of responses are we going to give back? So also about the cost to respond. We just want to point out this will be costly, but you have to handle them free of charge, essentially what the law says, unless the request is manifestly unfounded and excessive. There is an actual definition for that, but if you have repetitive requests, there are some limitations about access requests, but no limitations on deletion. We'll talk about that. If, there is a situation that may arise where you could charge a fee, it has to be reasonable. It has to reflect administrative cost, or you can refuse to respond. So really, you need to lay that out in your company's policies about when you would refuse a request and what are the limitations on that. So first one, right to access and portability. So it's similar to the GDPR, but there's no per se exceptions under the CCPA. And the difference too is that under the CCPA, really it's just rights to access and how you would receive that information, where GDPR is rights to access and how you would portability send that data to another controller under the GDPR. So it's similar but different. But if you're already doing this for the GDPR, you're close to complying. So here, and we haven't worked this all out, we're hoping the AG provides more guidance on it, but it is a lot of information. I mean, you got to provide the categories of personal information that was collected, the sources, the business or commercial purposes, the categories of third parties, the specific pieces of personal information. Everybody asks questions like, is that the actual data or is it just the data types? Well, we think it's the actual data. We probably will get more guidance from the AG. And then they have these requirements where you have to provide separate lists delineating when data was sold. So you have to do a separate list containing the categories of PI sold about that consumer and the categories of third parties to whom it was sold. Also, you have to do a separate list of PI about the same categories and divide it up in business purposes. I mean, this is a pain. This is an administrative regulatory pain. It differs from other laws, but really you're going to have to figure out how to do this. And really you're going to have to start doing this as of January. So you don't have a lot of time period. So you got to figure out, do we have the internal capability to do it? Are we going to go outside and purchase a technical solution? How are we going to do this? So I mentioned before, with regard to format of providing access, there is some language about what format you have to do to enable it to be portable. So information provided in response to an access request, you can do it via mail or electronic. If it's electronic, you must send in a portable format. It must be technically feasible in a usable format so that individual can transmit data. You got to think about how you're going to do that. Is it via email? Are you going to attach a file? You can't require an individual to create a portal to do this because that's a barrier to getting access. So how are you going to effectuate these rights? Individuals have a right, you get it 2 times per year. They can ask for data. The information disclosed to the consumer need to only cover the 12-month prior period, and it doesn't apply to single one-time transactions if that information is not sold. So again, that all has to be worked out in your policies and procedures to honor those requests. I would say most clients don't, go ahead, Amy.
Does this apply to employees as well? So if you have.
Well, Jennifer is going to talk about that. What's interesting is
We don't know.
don't know. We think it's delayed for a year. It's going to be delayed for a year, but ultimately it may apply to employees, which is a huge category of data. Rights to access, I think a lot of companies figure, okay, we can deal with that, but rights to deletion are hard. And you have to look at your technical systems and say, do they even have the capability to delete data? Consumers can request deletion of their data, not only to businesses, but also service providers. And as Jennifer talked about earlier, that difference. How do you deal with partial requests? What if you have records that have one person's information, but it could have multiple individuals' information? There's also so many exceptions, which the exceptions actually are helpful. And there's a lot more exceptions under the CCPA than there is under GDPR. So if you have a GDPR policy that's already up there, you need to look at it and then amend it for the CCPA because you have a lot more opportunity to say, no, we won't delete your data. But most companies, again, are just kind of going through all of these exceptions in their policies and procedures. So here's the big one. And this is, I think, really the reason for the CCPA is the right to opt out of sale of PI. People do not like their data to be sold. This is one of the main reasons why the law came into place. They want the ability to say, no, I don't agree to the sale of my data. Now note, this is an opt-out. In the GDPR land, most things are opt-in. And so if you're dealing with GDPR data and you're trying to sell it, most likely you're not going to fit under an exception with GDPR. So you're already in the opt-in world. But if you don't have to comply with GDPR, you got to think, how are we going to do this opt-out of the sale of PHI? Now, mind you, it's opt-out generally speaking. We'll talk in a minute about when you go with minors, it's actually an opt-in. But a consumer essentially has a right at any time to direct a business that PI about that consumer cannot be sold to a third party. If the consumer has opted out, you can't go back and ask them again to request authorization for at least 12 months. So you got to figure out how you're going to deal with that. And where are you going to put this do not sell link? It has to be in a clear and conspicuous location on the website, in a privacy policy, or any other specific description of consumer privacy rights. So you got to think about where are we going to be putting this on our site. Sale of minors. We're always worried about minors. If you just saw, there was a huge FTC action under COPPA just a few days ago, last week. But obviously the sale of minors information is more complex. So a business may not sell PI of a consumer if it's actual knowledge that the consumer is under 16, essentially 15 years and younger. They clarified that, unless the sale was affirmatively authorized by. Now, if a consumer is 13 to 15, the consumer can do it. If the consumer is under 13, it has to be by a parent. And they noted that you cannot have willful disregard of a consumer's age as deemed actual knowledge of it. So you can't, what we usually do is obviously put a statement in the privacy notice that we're not trying to attract business to any consumers under the age of 16, but we'll have to see how this plays out as well. So just remember, minors, more complicated requirements, and those are opt-ins. And I see you have a question back there. Don't ask us that question. I'm just kidding. A sale means if you breathe in the wind. No, a sale is very confusing and very broad. And it's a lot more than what you think is just a traditional sale. And so we would have to know probably the specifics of your question to really opine. But I just generally think over-inclusive than under-inclusive. And sale can mean a lot of things. And so that's a lot of what we're doing for our clients is looking at, the relationship between two parties. Is it a business to a service provider? Is it a business to a third party? What is the type of remuneration, if any? How are those payment streams working? And frankly, there is not a lot of guidance on it. So, I mean, you do have some of a delay, because they're not going to enforce till next summer. But when you're putting together your privacy notice and you're trying to figure out, do we need this button? Do we have to put this button on here? I mean, you got to go through a lot of transactions of data before you can figure that out. And frankly, if you don't do a data map and you don't understand whether there's any remuneration when you're selling data, you're not going to be able to answer this question, which is important because you got to figure it out now. Hi, Brian.
Has there been any guidance if a company just adopts an opt-in policy, selling data, through the button really doesn't make sense to people?
It doesn't. And actually, I love that idea. I mean, most companies don't want to do that because in the US, we're dealing with opt-out. But if you're in the GDPR land and you're pretty much opt-in anyway, that could be a very good solution, that we're just not going to sell data until we do an actual affirmative opt-in. We may see something from the Attorney General. Jennifer's going to do some updates. I mean, literally in the past hour, there's been new updates that have been coming out of the California legislature, and we don't have the Attorney General guidance yet, but that is definitely an area to follow, and that could be a good solution depending what company are you? What laws do you have to comply with? Are you in the GDPR land? That might be a good solution. If you're not, then maybe you just want to deal with opt-out. Are you, in the healthcare provider space or the financial space? Maybe you would come up with a different solution. So it's not a one size fits all. We really have to look at what laws you have to comply with.
You still have a situation where they change their mind.
Yeah, or they change their mind in dealing with revocation. I do want to talk about non-discrimination and financial incentives. They wanted to say, okay, so we don't want to create a scenario where, okay, I opt out of selling my data, and then all of a sudden the company says, all right, well, I'm not going to provide you the same products and service, or I'm going to lessen that. They wanted to make sure that there was no right to discrimination, but at the same time, they said there are some carve-outs to provide financial incentives. So this has been a very murky and gray area, and I just want to say, if you are doing this, if you contemplate this, there are changes today that came out. Jennifer's going to just do high level them, but we really need to work through your program because we were hoping for more clarity around rewards programs and loyalty programs to get some more clarification. And essentially, we really didn't get it. We may still get it, but this is a very complicated area. So if you are going to potentially offer some sort of financial incentive for gathering, sharing, selling data, using data, or you think that there might be some sort of non-discrimination practice where people that are opting into these programs are not, they're getting different levels of service, you're going to need to work through these rules.
Do you want me to just mention reward programs?
Yeah,
right
why
here?
don't you
It
do
might
that
make
right
sense.
now?
So what Jen was alluding to is there was a pending bill for a while that looked like it might go through regarding reward programs offered by companies to its customers. And literally my handwritten notes from this morning saying said that bill was being heard by the full Senate and it was expected to likely pass. And about an hour before we came down here, that bill was tabled. So it's not going to be passed into law in the near future. It could be brought forth and heard again in the next year. But right now, there is not going to be any exception in the CCPA for these reward programs, which was somewhat surprising to a lot of us.
Yeah, that was a shocker because it's very murky, very murky. So in sum, before we move over to Terry, and we'll be back on this issue, is what are really your action steps? You need to think about how are we practically going to do this? What are we going to do with our privacy notice? What are the technical mechanisms? How are we going to implement these buttons? What are our policies? What are our playbooks? What are the written responses? You want to lay this all out. And now we've done this for a ton of clients, so we have lots of model forms here, but who's going to handle it internally? How do we write this? Is it going to be a customer service rep that's going to be interacting? Like, who is that person that's going to be B2C? Who is going to have to implement this? What kind of level of documentation are you going to provide? What are the methods to the consumers to make these requests to you? How are you going to comply within 45 days? How are you going to find the data in your systems to gather it all? How are you going to determine what exceptions apply, for example, for the right to delete. What are you going to do with somebody that opts out to the sale of your data? Think about it. You have huge data sets that are going outside your company, and Jen Rathburn does deletion requests. That's what I'm going to do. I'm going to run around and delete my information everywhere. But how are you going to deal with, and honestly, you probably won't get a lot of requests at first, but how are you going to deal with one person and a 1 million person data set that you're sending? What are you going to do with me, the pain in your side that says, I want my data deleted? It's going to take forever to figure out even if an exception applies, but then how are you going to just manage this? But I'm telling you, this is coming. It's not just California. It's going to be other states. It could be federal privacy legislation. So whether you're perfect today, this is what's coming on the forefront. And now I'm going to turn it over to Terry to talk a little bit about what reasonable security means under the CCPA.
Yeah, this part will be brief, and then we'll get a little bit more into it in the implementation side. So there are, okay, all right. There are over 20 instances of the word reasonable or reasonably in the statute, okay? So big picture, organizations have a duty to protect the harm to others. And now privacy, the impacts of privacy on their consumers is another form of impact that now organizations need to consider the harm. Okay, so that's big picture. And built right in the statute, businesses have a duty to implement and maintain reasonable security procedures and practices. We'll get to how that language got into it a little bit later on from legal perspective. But what we're talking about here is organizations can adopt a duty of care risk analysis standard that already inherent in the framework allows organizations to consider the harm to others, specifically the privacy hit. So if you have a proper risk assessment, risk management framework that considers the privacy hit to your consumers, you can actually build this into your risk management framework. So if you want to raise your hand, you can. How many have a robust risk management framework today? Okay, so that means the others are working on it, is what I'm assuming, or you just don't want to raise your hand, which is fine. This risk management framework, this duty of care risk management framework can now be used to talk about the reasonable security controls to protect the privacy information as it's going through its collection and procedures and how the organization is actually operating, but can also be used to defensively talk about how they're meeting or meeting the intent of, or maybe not meeting the intent based on the burden of the privacy rule itself. Okay, so we'll get into what that means, but this is the real duty of care. This is the real legal perspective of, is it a burden? Okay, so this is another new regulation that's a burden to organizations. How do we balance the organization's mission and objectives to operate with its obligations to protect privacy? So there's a way to do that, and we'll show that in a little bit. Until then, we're going to go on to penalties.
Thank you. Okay, so let's talk about what happens if you don't comply with everything that we were just talking about. So one option is the California Attorney General can bring regulatory fines. So the regulatory fines are $2,500 up to $2,500 for unintentional violations, up to $7,500 for each intentional violation. There's also, and this is what people are talking about more, the potential for private rights of action, so class action lawsuits potentially. Those statutory damages range between $100 to $750 per consumer per incident, or actual damages, whichever is greater. I'm going to talk a little bit more about the private right of action in a bit. There's also, of course, the reputational harm that comes from, having a breach of CCPA, just like it comes from having any type of data breach or data-related incident. And then there's this broad language that also permits any additional relief that the court deems proper. So the courts have a lot of flexibility there, and they're told to consider relevant circumstances, including the seriousness of the violation, the number of violations that a business has had, the length of the violation, the willfulness of the violation, and really the organization's assets, liabilities, and just honestly the ability to pay whatever damages the court might put forth. So a note on the private right of action, which is what is probably one of the more talked about things with CCPA. So the private right of action is really pretty limited as opposed to what it could have been. So the private right of action is limited to bringing an action against a business that violates its duty to implement reasonable security procedures and practices only if that failure results in a consumer's personal information being accessed or disclosed essentially improperly, and the consumer has to give the business written notice of the CCPA provisions that the consumer believes were violated. If those violations can be cured, the business has 30 days to cure those violations. So if the business cures the violations and they send a notice back to the individual containing certain specific requirements, but essentially saying that the violation has been cured and there won't be further violations, the consumer then would not have the ability, generally speaking, to bring a violation or a private right of action for that particular violation or breach of CCPA. So there are a lot of outs to the private right of action. It's not just a broad private right of action for any violation of CCPA like we could have seen in this law. It's actually pretty narrow, I would say.
I think this is the most common question, however, I get from most clients. So let's just talk about this. If your organization does not provide access within 45 days, can you have a class action suit? No. If you give information out and do not verify individuals correctly and you're giving it out to the wrong people, you could be sued for a class action suit. But if that individual asks you, they first have to tell you to cure that, and you don't cure that within a certain period of time, that's the only time then a class action can be brought. So if you get complaints by individuals about violations, it's not something you can ignore, because most likely what is really meant is that a class action suit may be coming as part of that. So you really have to pay attention to it, but it's not each violation of the CCPA. So if you don't have policies or procedures, you don't do an opt-out, some things, it has to be an actual breach of information related to that part. But it's a very confusing piece. And we know 100% that class action plaintiffs' lawyers are looking at this law, in particular out in California. I see smirking people in the audience. It's not a joke. So people are looking at it. And frankly, that's why the Attorney General and that's why the legislator put it in there, because they want to make sure that they don't have enough resources. The government does not have enough resources to go after all these companies. So bringing in that class action piece is a threat to companies to really get moving on CCPA.
From a practical perspective, it seems, we're going to talk amongst ourselves. From a practical perspective, it seems like if a consumer is complaining about it, it's because they've already been injured. So what is it that the company's going to cure, that they're not going to continue getting injured? If my information's been sold 17 times and then that organization sold it, their likelihood of really curing that, it's going to be like impossible, I'm thinking, right?
Most definitely. There's other things that could be cured, though. Access, deletion. I think the Attorney General, hopefully, will give us more guidance. If they don't, it's going to be by case law, which is painful, and so you're going to have to take those requests seriously. We're going to have to build some sort of legitimate argument that we cured that problem. Maybe it's stop selling their data. Or maybe it's you gave data to the wrong person. Okay, well, we had a systematic error that we corrected. We won't really know until we get more guidance, but it is a very good question. Yeah. We'll have to see.
So just a couple notes here regarding potential for litigation. So we do expect, I think Jen has said this, as soon as CCPA goes into effect, January 1st, we expect to see consumers start exercising their rights under CCPA. So we're really recommending, which we've mentioned, have everything in order to the extent you can and expect that those requests are going to be coming in as soon as the law goes into effect. We've mentioned the 30-day cure period is, of course, limited to things that can actually be cured, as we've just been discussing. Terry is going to get into this a little bit more, but whether an organization has used quote unquote reasonable security measures could be something that's left up to the judge or jury, and it will be something that's left up to the judge or jury in litigation because that's the way it is. So what is reasonable security? That's a huge question that comes up so much in our business, and Terry's actually going to end our presentation by talking about that. You're not? I'll take it over. I'll do it, Terry. No problem. So again, as Jen mentioned, the potential for litigation is not just how an organization is using data, or how business is using data, which is a lot of what we've been talking about here and a lot of what the CCPA deals with, but maintaining it properly, because that private right of action, again, is really tied to a data breach. So you're wanting to make sure that there isn't an improper use or disclosure of that data, giving rise to the potential for that private right of action. And we mentioned this a number of times, but it's so important. The California Attorney General is going to issue additional regulations. So while we hope that provides some clarification on a lot of these issues that we need further clarification on, there's also then the potential for additional violations if you're not following that guidance from the Attorney General. So the potential for additional penalties or litigation based on violation of those Attorney General regulations. So pending CCPA amendments. So bear with me here. As Jen mentioned, we've been following these all day and keeping track of them. So the slides are not so much outdated, but if you could see my handwritten notes scribbled out throughout the day as things have been changing. So AB 25.
Can you first tell them just what's going on with the amendments, just for background?
Yes.
Okay,
so
that would be
this
helpful.
law was put into place. I think most of you know this law was put into place quite quickly to avoid a ballot initiative. So if this law wasn't put into actual law in California, it was going to go to the voters by a ballot initiative. And so legislators decided they didn't want it to happen. So they passed this into law more quickly than they normally would have. And there were just very clearly drafting errors and things like that in there that.
And written terribly, for those of you who have read it. To sum it up
Just because
bluntly.
words are missing and things, Jen, and don't be so harsh. Everyone knew the law was going to have to be amended. Everybody knew that. And so there are things out there that are like the cleanup bills that we know are going to go through, which are fixing the missing words, the things that just do not make sense to anybody in the law. But there's also a number of, because it was put into law so quickly, it didn't go through the normal process where everyone, had their voices heard, and the law was kind of whittled down to a law that different parties had negotiated like would normally happen. So that's happening right now. And tomorrow is actually September 13th. Yeah, tomorrow is the last day for the Senate to vote bills into law for them to be effective January 1st. And so that's why so much has been changing this week and today in particular. So tomorrow's the last day for the Senate to vote those bills into law. And then October 13th, so a month from tomorrow, is the last day for the governor to sign bills into law. So the Senate will be sending them to the governor. The governor has until October 13th to sign those into law if they're going to be effective by that January 1 start date. So that's what's going on in the background here. So you asked a question about employee data and we laughed. So we're pretty certain that the employee data is going to be largely exempt from CCPA for 1 year. So just 1 year, not a very long time. You should really be thinking about how you're going to treat employee data under CCPA right now. It's going to be likely going to be exempt from all of CCPA, except for the private right of action for data breaches and the obligation to inform the employee as to the categories of data that you're collecting about them. So what's going to happen is an employee is not going to be a consumer. They're going to be exempt from the definition of consumer, except that if there's a data breach that would allow them to file that private right of action that we discussed, they still have that right. And you still have to tell the employee or potential employee, a job applicant, about the information that you're collecting about them. Otherwise, for 1 year, we expect that employee data will be exempt from CCPA.
Do we know how it's going to be treated if you share that information with a third party and then they are breached?
So
You're slacking on your duties.
Oh.
I'm just kidding.
Sorry, do you know how that information will be treated if you share employee data with a third party and then they are breached?
So are you wondering if that counts as your
Yeah.
breach? So
Yes.
and
So
we-
if you collect the data and you give it to HR gives it to whatever for healthcare, whatever, incentive programs or whatever you have, how that then will be treated.
Yes. Well, and it's the reason why third-party vendor management is such a
Yeah.
big deal today, right? 70% of breaches are the third party's fault, right? And so the litigation is going after the organization. They need to manage those third parties, the contracts and the oversight, and they're responsible. You can't simply take an IT function or business function and outsource it and go, huh, thank goodness, I know I'm not liable. No. You've outsourced it, no different than outsourcing it to a new set of hires that you now need to manage. It's no different. It's just an outsourced IT asset or business asset from a third party, and you have to manage that risk just like an internal asset. And so, yes, you're responsible.
And that assumes they're providing like a service to you, the way he's describing it. If the data would go over legally to someone that would then own the data, simply put, then that usually under the law is considered their data breach and not yours.
Yeah, that's a good point.
Yeah, so it depends on your relationship with that entity.
If it's a discovery request from like a legal entity and you send it over, then once it's over, it's going to be their responsibility to safeguard that.
Well, it's not so clear. This is what I brought up earlier. Okay, so you really have to think, who am I and who is that other party I'm sharing data with? And yes, there's an exemption that if your service providers under the CCPA have a breach, you're not liable for it, but that's just one law. That's just the CCPA. And, you are in a bunch of different markets. You have to have some sort of strategy about, at least think about your 10 top most common data use cases. And we talk about data use cases. I'm previewing ahead, so I'll be quiet because we're going to get to the summations about practical, but you have to get to the details because all these laws are what type of data do you collect and who do you share it with and what is that purpose? But you have to do that risk analysis of, do we want to make them our service provider or do we want to say, no, they really are a third party? Sometimes you can't choose that, but you get under the data breach laws, under the state data breach chart, if vendors, generally speaking, if they have a breach of data, they just have to report it to the owner of data and then they're hands off. And in the past, vendors used to take liability for that. But vendors are saying now, shit, that is too much money. We are not taking liability. Our obligations are on the law to tell you about the breach and have fun with that. So it is very important to think through these processes about, are you the actual owner of the data or are you the provider to the owner?
Right.
We got one back here, Jen.
I was just curious in terms of the employee side, is that going to relate to employees that are specifically in California or is it businesses that, yes? Okay.
Yep. Yeah, because it's going to exempt them from the definition of consumer, and consumer, paraphrasing, is a California resident essentially.
Today, but there'll be other state laws that are put.
And we keep referencing that, and you had mentioned having to opt in for the sale of data, and New York's CCPA equivalent that didn't go anywhere, so far hasn't gone anywhere, actually required an opt-in to sell data and was much more stringent than California's. So when we keep previewing that this is just the beginning, we know it's just the beginning, and we've seen worse things than CCPA proposed in states already. So AB 1564, the one in the orange box up here, under CCPA, businesses are required to maintain at least 2 methods for consumers to submit requests to exercise their rights. This bill, which we again expect to pass, just like the employee one, says that businesses that operate exclusively online and maintain a direct relationship with California consumers only have to, they can essentially just make requests come in by email. So you operate exclusively online. You don't also have to have some toll-free telephone number or something, because in reality, if you're only online, your consumers are going to be submitting those requests electronically. This bill is acknowledging that, and we expect it to go through. Reward programs, nothing's going to happen with that right now, as I mentioned. And these are just a couple of the more important ones. There's a bunch of other bills still pending as well. A couple that might be less applicable to most of you, but we wanted to point out there is an exclusion applicable to car dealers and manufacturers where they can share vehicle information amongst themselves, specifically for repair purposes. And that sounds very specific, but it's important because it wasn't even going to permit them to do that under CCPA. So something they very clearly need to do for their businesses just wasn't something that was flushed out when this law was put into place, because the organizations, the lobbyists, didn't have a chance to come forth and talk about these very practical things. So it's things we're seeing in the bills now, carving out these pieces.
And I just have another note. I do a lot of work in the insurance space, and the insurance industry really is screwed up by this. I mean, there are some exceptions under GLBA and the financial,
Yep.
but the insurance industry tried to say we want exclusions, generally speaking, for the insurance industry, and we don't think they're going to pass. So if you're, implicated in that industry, unfortunately, there's not a lot of help for you
Right.
at this moment. I mean, healthcare providers are really excluded out. The insurance industry, though, you're still in the game.
Yep. We also expect the definition of personal information we don't know for sure that government records are going to come out. And the reason, there's some information that seems like it's publicly available that's in government records, but it's governed as personal information. And a lot of businesses are not happy about that. If this information is very publicly available, why are we required to protect it in accordance with CCPA? So that type of publicly available information might come out of the definition of personal information. In that same bill, de-identified information and aggregate information is going to clearly come out of the definition of personal information. Everyone treats it that way right now. We know that de-identified and aggregate information isn't really intended to be treated as personal information, but this bill would really clarify that, so it's very clear in the law.
But I would say what you think is de-identified and aggregated is not what
Yes.
the law in all aspects.
Yep.
So if your business people come to you and say, oh, this information is de-identified, do not trust them because it's not their fault, because an average person would think that is de-identified. But generally speaking, what a business person thinks is de-identified is not de-identified under the law. So make sure that you remember at least that point.
Yes, and that's the case really in most data privacy and security laws. That's the case. So one last thing I want to mention about pending bills. Something that's been talked about a lot today is there's this potential business to business exception that's going to be treated somewhat similar to the employee data exception, where we might for 1 year have an exception for information from employees, owners, directors, officers, contractors, profits, and government agencies. So again, people acting in an employment context. And so the exclusion would apply to communications from those individuals to a business that's solely in the context of the business providing products and services. And I'm really paraphrasing what that is, but essentially consumer is defined so broadly that it pulls in people that are California residents, even when they're not acting as a consumer. So if I'm working at a Foley and Lardner law firm in my business capacity, and I'm communicating with a business, even though I'm in my business capacity and I'm not a consumer, the CCPA is protecting my information. And this business to business exception, again, would treat those communications, that personal information, similar to the employee data exception, where those business communications would not be protected by CCPA for 1 year. Not for forever, 1 year.
And think of Salesforce, business contact information. And again, this just came out this afternoon, so it's very dicey. But I know you have a question over here. It's one area we're following.
This probably is a wacky question, but within the last couple of weeks, the Trump administration has chosen to attack or address, shall we say, car manufacturers who are trying to hold on to emission standards within the state of California. So my question is it possible that the Department of Justice in Washington, given guidance by various chambers of commerce who are trying to protect the interests of businesses, could try to water or essentially use legal means towards this law in California, not because, partially because there's antipathy within the administration for things that are California oriented, and the fact that California is taking the lead nationwide in creating this law to affect that, which might run counter to whatever the political agenda is of the people in Washington.
Well, I mean, anything's possible, but I was really hoping, Terry, that you would address this question. So Terry.
We're going to table that one till after, okay?
I mean, anything's possible. I mean, I'll just tell you, for one, from a legal perspective, and I'm sure you all realize this, California usually is on the forefront of any sort of developments. In particular with, I mean, when we talked about this data breach chart, California is one of the first states, obviously, do that. Because there is so much tech industry out in California, just hands down, they are the first state almost always to come out with privacy and security related laws. So there may be some sort of connection, Trump industry politics, et cetera, but the reason why is because there was a deadline. So I don't think that they're probably related. They had to come up with the pending legislation and the amendments by tomorrow. So I don't think they're related, but could be.
And a lot of these have been pending for a while. So a lot of these, in some way, shape, or form, were pending in the spring. And then the California legislative branch was on vacation for part of the summer. So they came back in August, and then we've really seen a ramp up of them trying to get these bills revised and pushed through. And then this week, we've really just seen the push to get them done. And I'll turn it over to Terry now if no one else has any questions on those.
Are we in
I think
preparing?
there's a part that you're going to go over on the preparing.
Oh, sorry, Jen, skipped you.
You skipped me. So here's the bottom line. If you take away anything else but from today, think about what do you have to do to prepare for the CCPA. Literally almost all day, every day, we're doing CCPA questions. It was GDPR, now we're moving to CCPA. So what do you need to do? Unfortunately, you have to do a data map. I'm sorry to break that to you in some sort of way, shape, or form. Everybody hates this, but you have to figure out where in the heck is your data. What kind of data are you collecting? Who are you giving it to? What purpose are you using it for? Because honestly, if you don't know that, we can't answer any questions because that is the way these laws are structured. So we can't tell you what to do unless you have a general understanding of where that is. We can help you with data maps. We have questions. There are many vendors that have technical solutions, but unfortunately, it's going to take some work. It's not a quick question. And Frank, you're going to have to do it. You're going to have to come up with a committee. Usually the best people that know where your data is your marketing departments. Marketing knows where it is. IT may know where it is, mostly marketing. But you're going to have to do some sort of data map to answer what data do we collect, what data do we disclose, why are we disclosing it, and to whom are we disclosing it to? Because we can't provide any answers to you. You can't update, which comes in the next part, your privacy notice. You can't talk about what you're doing if you don't even have any idea. So it's not worth calling us until you get that figured out. But we can help you do that. We can help you data map. We can give you some technical solutions to do that. In fact, that's another thing I mentioned. We're going out to IAPP. We're pulling a bunch of solutions from technical vendors on how to answer consumer requests. But there's also many companies from a technical perspective that can help you with data mapping. The next thing is, how are you going to answer all these consumer requests? Developing your playbooks, who is going to be talking to consumers about this, what kind of language you need to write instructions to. Most likely it's not going to be your legal department answering all these. It's going to be a compliance department. It's going to be some direct B2C customer rep. So you're going to have to write it in that language. How are you going to honor access requests? How are you going to honor deletion? Where are you going to technically do opt-outs? If you're going to have to get specific minor consent, really opt-in. When we say that, how are you going to do that? How are you going to rely on these exceptions? What are your technical capabilities and who is going to own that inside your business to do that within 45 days or at the most 90 days? So you also have to figure out how you're going to implement the pure opt-in. Again, I mentioned if you're in the GDPR space, you're more used to opt-in. And what I mean by opt-in is in the United States, before GDPR, everything was opt-out. You could just collect, do whatever you want, offer somebody an actual opt-out. You were in the opt-in space on GDPR and with minors. You're going to have to review your policies on, are you doing any sort of discrimination activities or offering financial incentives, as Jennifer mentioned, on loyalty programs, rewards programs. You're going to have to focus in on that. And the biggest issue is your service provider contracts. We have many clients that have to comply with many different laws. So we're talking about CCPA, GDPR, HIPAA, New York cyber regs. So really, you got to think about what are all the different laws that we have to comply with and what are we going to pass through to our vendors. And not just the legal requirements that we're going to pass through to our vendors, what kind of IT security technical controls are we going to require our vendors to comply with? Are we going to just do this via agreement? Are we going to do a vendor management questionnaire? Are we going to require them to do audits? What are we doing? Because every time you bring a vendor, as Terry mentioned, into your environment, you're bringing risk. So your security is only as good as your vendors, and how are you vetting them? But you are going to have to do these vendor management contracts, and it's not just about the CCPA, it's trying to do the kitchen sink. And so we're doing a lot of that work for clients. We're trying to figure out how can we put all the laws into an agreement so it works, that you're in compliance with all these different laws. And now I'm going to turn it over to Terry to talk about implementing risk management.
Jen,
Sure.
yeah,
Yes?
Jen, real quick,
Yep.
businesses that can manage all this expensive and it's time consuming, well, what about smaller businesses that may be individually owned, or maybe 5 or 6 people that work for that individual? That would be so expensive and time consuming that they might not be able to do that. Will they be required to do all this?
Well, it'd be
as well?
scalable. I mean, going back to the slide Jennifer had, I think it was right in the beginning on scope. I mean, you're not going to have to comply with CCPA because you're just not going to have that level of assets or doing that type of data transfer. So small businesses are excluded out of a lot of different laws, and it's scalable, and they're not even aware these laws exist. So if you go to a small business, feel free to know that your data has no regulation. No, I'm just kidding.
That's
But-
the fact.
That's a
Right there.
fact.
Yeah, based on the number of data breaches, I get 9-person firm calling me all the time going, we had a breach. Yeah. That's a surprise. Okay. It's just me a little more comfortable for me to stand up with my current situation here, so.
Do you want this?
Yeah, I think I do, because it didn't seem to. Okay, so risk management isn't linear where you're going to do this like as a last thing, like we're showing it. It's actually something we'll probably do up front, okay? So while you're doing your data mapping, you're going to want to retool your risk management framework to make sure it meets duty of care and considers the harm to others outside the organization, specifically because this is about harm outside your organization, about the harm you can do, right? So implementing a robust risk management framework, how many have one that's based on ISO 27005, NIST 830, Risk IT, something that's registered as like that? Yeah, okay. And then how many have heard about duty of care risk? Is that something that we've heard about for those that have been here before? Okay. So we want to update our controls to make sure that they're reasonable and they fit within the risk framework. So in this age of risk, okay, and this is something that Jen put into immediately and periodically thereafter, review and revise all your organization's security policies and procedures. So as you're performing ongoing risk management, you want to update your policies, procedures, and controls to make sure you're bringing your risk down to a reasonable and appropriate level. I'm going to stay high level on this. I'm not going to get real in the weeds. I'm just going to give the construct of the mindset of duty of care risk and how do we meet this standard of reasonable or reasonably. I like that word reasonably throughout the statute. So in the age of risk, things are not black and white. They are actually lots of shades of gray. And so the goal here is to figure out what is enough, what is meeting my duty of care, and where is the line between my duty and burden. So that's really what we're going to try to figure out. So we need to think through the likelihood and impacts of the threats, right? And we want to reduce the unacceptably high risk, and we want to consider the burden of all those controls. So we want to manage that. All right. So really what we're talking about is you look out for me, I look out for you, right? You look out for us. So this is really the golden rule. How do we implement the golden rule? How do we accomplish that? So we want to protect the harm, the foreseeable harm that we could do as an organization, but not harm, but not so much so that we harm ourselves in protecting others. Okay, so that's this reasonable person doctrine that we're actually operating by. That's how we get the word reasonably and reasonable security solutions, right? Where does this come from? Well, it goes back to the 40s with negligence laws, but in actual regulation, it goes back to 1993. So Executive Order 12866 Clinton signs it. It says that all federal regulations going forward are going to have a cost-benefit analysis so that they're not burdensome, right? So we're not actually having to meet the letter of the law on each one of these. If what we're doing is not actually going to measurably reduce the risk or harm to others, but is a huge burden to me, I'm not expected to do it. That's the theory behind this cost-benefit analysis for federal regulations. So since then, all regulations, even including the California Consumer Privacy Act, right, it has the word reasonable and appropriate throughout all of this stuff. And what does that mean? That's that cost-benefit analysis that goes back to this executive order from 1993. So that's kind of the history part of it. All right, so the courts look for, if you're in front of a judge because you had some privacy action against you, that you had a breach or you didn't meet your privacy obligations, right? They're going to be looking for, well, did you reasonably apply the standard? Did you reasonably apply controls? And they're going to go through a calculus of negligence. And that calculus is going to look like this. Was the harm foreseeable that you could cause? What was the gravity of those injuries? And what would have been the burden to you to actually reduce that to a reasonable and appropriate level? That's what they're going through. It's the multi-factor balancing test. That's what judges are, by law, have to go through, okay? So DACRA, and short little side story because we're talking about California. So a few years ago, Kamala Harris is on TV talking about, if you want to know what reasonable security is, it's you implement the CIS controls. Now, it was a little misinformed, okay, because we said, oh my gosh, that's not right, because you just don't implement a raw set of controls. You use a risk assessment, then go to a control standard and implement the controls that are reasonable from the control standard. Unfortunately, the Center for Internet Security did not have a risk assessment method when Kamala said that. So we approached the Center for Internet Security and said, you have a problem. They said, yes, we do. So HALOC and a bunch of our members, we actually developed the duty of care risk analysis standard. And then we also wrote and published, and then the Center for Internet Security published the first written methodology based on duty of care. And that's all because of what Kamala Harris said when she said, if you want to know what reasonable security controls are, it's the CIS controls. Now we can say that kind of yes, because now you can use the CIS RAM, determine which controls you need, go to the CIS controls and you can implement them. We made sure she's not a liar today if you actually go back and look at that.
Yeah, no,
okay?
it's good. Well, let's some background on that. In California, you have to have reasonable security. And so if you had a breach, this is way before any of this happened.
Yeah.
And so everybody was asking in California, what the heck is reasonable security?
Yeah.
So, and that was really the only state law. So she actually said, okay, I'm going to define what the heck is reasonable security, which was the only guidance that was provided across the country of what reasonable security is. So at least she did something, and now we have a robust framework. So that's really where all the background, where it came from, is what in the heck is, clients ask me all the time, just tell me what reasonable security is, I will do it, then I will have a safe harbor, and nobody knew that answer. So she is the first one that really brought that up.
She brought it
tried.
up.
It was good. It was a lawyer's,
start.
attempt at trying to do reasonable security.
As another sidebar, so the Sedona Conference, Working Group 11, is currently defining the definition of reasonable security. And for the attorneys in the room, you might know that Sedona Conference is a think tank. They solve difficult legal issues. They publish papers that then can be referenced by judges, regulators, plaintiffs, and defense attorneys in cases, okay? That definition is coming out next week because Sedona Conference is meeting Tuesday, Wednesday, Thursday of next week. That paper has already been documented. It hasn't been published or released to the public. And I cannot tell you that it is based on duty of care risk. So that is not something I can tell you right now. It is not based on duty of care. I cannot tell you that. If I could tell you, I would tell you that it's based on duty of care risk. But the Sedona Conference is going to publish that next week.
Well, what do you think it should be?
So we have members of HALOC Security Labs that have seeded that membership of that working group, Sedona Conference. Again, I cannot tell you whether the results of the definition of reasonable security and the test for reasonable security actually line up with the DACRA standard. Okay, enough of that. So I mentioned that the first published methodology is from CIS, the Center for Internet Security. I mentioned the whole Kamala Harris story. You can go and download the standard for free. You can go download the templates for free. You can download the videos for free. It's all free. We gave it away to the world because we realized when we were doing litigation support, we were pummeling the defense, absolutely crushing them because we just were like, So it sounds like you knew this was happening, but you didn't do anything about it or didn't calculate the burden and prove, and they're like, and they just couldn't do it. So it's like negligence all over the place. So organizations will be lining up for this, and especially after Sedona may or may not publish the definition of reasonable security next week. So in its basic form, it looks like this. In my risk assessment, I need to consider the harm to me, which all risk assessments have already done, right? Everyone knows the risk assessment is like, what's the harm to me? That's the risk, right? What's the risk to me? But in a duty of care risk analysis, I need to consider the harm to others. That's the most basic form. I need to consider the harm to others, right? So from a privacy perspective, is my profit on track or not profitable? Basic form, right? So it's acceptable, and I'll invest against things that put me into an unacceptably profit state. Same thing, I have to equally manage and invest against the harm to others from a privacy perspective. I have to actually show the balance of how I'm investing in both. I can't show that I only invested in things that were going to affect my profit, and I measured, but I didn't really invest against those privacy concerns. Yeah, I risk assessed against it, and I determined I wasn't going to do anything about it. I have to show the calculus, because there are situations where it might be too burdensome to request that for consumers to request that information, and I need to charge them, or I need to say that's not a reasonable request, or it's excessive. And I can do that through my risk management framework if it's based on duty of care, because it's the only one that's going to show the burden of the safeguards versus the original risk I'm protecting against, in this case, privacy risk. Too fast? I was trying to get done before 7. All right. So in a more detailed format, as I showed just the basic format, harm, no harm, right? Okay, so here we really have different levels. Remember, it's shades of gray. So there's negligible hit to maybe my profit and the consumer harm. There's acceptable hit, right? So in this case, hey, if that private information was encrypted and it got out, it really didn't have any harm. There's even people that do breach notifications that say, hey, we lost a couple tape drives, it was encrypted. Why do they do that? They want to get ahead of the storm, right? There's no news once they said that. It's like, oh, okay.
I'm not sure I'd recommend notifying about encrypted lost drives, perhaps.
There's for and against, but that's why we see that happen, right? They want to get ahead of the storm. And then there's the unacceptable level, which I will invest against, right? It's foreseeable, and it's an unacceptable hit to my either my profit or the privacy, right? In this case, I defined it as recoverable harm among a few consumers or minor harm among many consumers, right? So I'm going to invest against that. And of course, it gets even higher and then more catastrophic. So as I rate my risk, the more probable something is and the higher impact it is, those are the things that on my risk register I'm going to make investments on in the immediate, near term, and long term. And they're going to be prioritized against the most likely, the foreseeable. Remember, the multi-factor balancing test says, is it foreseeable? What's the gravity of the injuries? And what's the burden to you to actually do something about it? Those are the 3 considerations we need to have within our risk register in order to actually show why we're prioritizing things or accepting risk or saying that's too burdensome right now.
And this is what your board or your C-suite wants to know. Like, just break it down. Why should I invest money here? And this is why. I mean, you have lots of gaps, both on security and privacy side, but you can't just come in and say we have all these gaps. They want to know, okay, we don't have money to fill all these gaps. Like, just tell me, cut to the chase and tell me where we need to invest our money. And that's what this framework does.
Yeah, it's really a tool for the board, right? So what we're talking about is not just profit and harm, but we have to break it down to the organization's mission, objectives, and obligations. Did anyone see the CEO pledge and all the discussion about social responsibility in recent news, right? If you look at that, every one of those reads like a mission, a objective, or an obligation. Every single one of them lines up against this. And what they're really saying is, we're not going to just look at profit. We're going to actually respect our duty of care. That's what they're saying, okay? So it's really interesting how all this stuff is coming together at the same time. All right, so different missions among the different organizations. You might be able to see one of yours up here. So a commercial bank, their mission might be customer performance, their objectives might be return on assets, and an obligation might look like protecting customer information, right? If I skip on down to manufacturing, my mission might be this really awesome, something about a product and our mission around that product. Profitability, of course, maybe as an objective, but protecting intellectual property, right? Might be something else I'm trying to protect against. Electrical generator, provide power might be the mission. Profitability might be an objective. Public safety and privacy I may have multiple missions, multiple objectives, multiple obligations. All right. So how does this actually map out? Because we might have different levels of acceptable risk, different appetites for risk. And I only have just a couple more minutes, and then I promise we'll wrap up. So in traditional risk, likelihood times impact gives me a risk score, right? So if something's foreseeable, and I have an unacceptable risk, and that unacceptable risk can be to a mission, objective, or obligation, I get my risk score. In this case, a 9, okay? So that's my score in this one. For those that are a little more conservative, I've had organizations say, you know what, I realize it might not be foreseeable, but it's possible, it could happen, but it has an unacceptable hit, I'm gonna invest against that. So in this case, their risk tolerance is lower, it's at a 6. And think about a lot of the SaaS providers or internet providers out there where they've got clients and those clients have millions of clients. Like the risk is really, really high if they have a breach, right? So we wanna make sure we're doing something about that. Okay. Yeah. Sure.
I know people jump to risk scores all the time.
Yeah.
Sometimes they're negligible. In fact, it's 5 times 1 is 5. If you took out the 5 times the catastrophic times the not possible, it's also 5. So those 2 different types of risks are really very different type of exposures.
Yeah.
So be very careful with just the risk score.
Let's talk about that, right? So you're talking about an impact that might be negligible. Very common, but it's not going to have an impact. So that's the 5 times the 1 score that you're talking about. So do we really want to invest against something that, hey, it's really common, but it has no effect on my mission, it has no effect on my obligations, and no effect on my obligations or objectives in the organization? Would I invest against that? Probably not if I have a catastrophic issues. Now, if it comes down to it, where that's all I have on my risk register, maybe I would. But I'm going to have a heck of a time explaining to the judge why I was investing against my 5 times a 1 when I had 25s and 20s out there that actually led to a breach of impact. Now, the opposite, not possible, but catastrophic. Well, okay, sure. Could a plane hit a building and burn it down? Before 2001, we didn't think that was possible, right? So did we have any precautions against that? No. Once it was foreseeable, it changed from not possible or not foreseeable to foreseeable, and now we have all of our security protocols in place because of it. So I respect that you're saying. Now, the biggest one I get is, what about threats that aren't foreseeable yet? It's brand new. It's never been expected. We need to kind of keep going. That's the one that's probably the hardest one to answer. And my answer to that one, so I asked the question, I'm going to answer it, is until you've addressed all of your foreseeable risk, don't consider investing in all the non-foreseeable risk at this point until you've clobbered all the foreseeable ones that are expected and catastrophic, high, and unwanted.
What I was trying to reach out with you a little bit more clearly, that people should be really careful about just taking the numbers.
Yeah.
Don't just take risk score numbers and say, I'm running to the races.
Sure.
Here's what I'm going to do. Try and look behind the numbers. What's going on there? Like the not possible.
And we can talk. I'm staying real high level on this stuff, but there's a lot of calculus that goes into descriptors on this that the business can override some of the stuff and decide that they're going to actually invest against it. I want to keep things. I only have a couple more. I want to finish, and then we'll wrap up for questions. All right. So how does this actually play out? So I have a risk. All right. I have a risk to my obligations. In this case, maybe it's a privacy obligation. All right, and it has a score against it. So I have a safeguard. I put it in place, or I at least run the numbers to see if I put it in place what my new risk is. So under the duty of care risk model, I look at my risk. Okay, my obligation score now is acceptable, but my hit to my objectives is now unacceptable, and a hit to my mission, my ability to actually operate and do what I do, has taken such a catastrophic hit. I cannot actually put that safeguard in place. It could be that a safeguard doesn't exist today because these businesses have been operating and doing what they do for many, many years, and now we're throwing regulation on top of it. There may not be a technology or process today, right now, that exists that is not overly burdensome for them to actually affect and comply with all these statutes verbatim. And that's why they'll need to have this calculus to show that this is a burden to us. And when the time comes where it's no longer a burden because technologies come along or processes, they were able to change their process over time, all right, they'll still manage it. They'll manage the risk to it. So if we move on to the next one, I put in a different safeguard, an alternative safeguard. Okay, so I keep looking at my safeguards. This one actually brings down my obligations risk to acceptable, and my missions and objectives are still within the green and acceptable level. This is the big cost-benefit analysis from Executive Order 12866 now has manifested its way throughout all of our regulations, including California Consumer Privacy, where it says the word reasonable or reasonably, it's talking about this. You need to measure the safeguard risk, not just that you cover the original risk, but what's the cost to me to do that? What's the burden? Well, how does it affect my mission? With compliance, here's how it gets affected in the age of risk. So this is strict compliance. If I do a gap assessment, the yellow is all the stuff that I need to do, okay? In the age of risk, if I were to apply risk on this, I look at this is my line of reasonable. Everything to the right was unreasonable or a burden to me. And I have to, if I have a proper duty of care risk register, I can actually show this burden. I can actually show why I'm meeting my obligations, my duty, and why the other things that I'm not doing are actually overly burdensome today, okay? So in addition to just the security controls around the private information that's flowing around, the other statute items you can also affect with this risk register, right? So for instance, the business shall bear the burden of demonstrating that the verified consumer request is manifestly unfounded or excessive. We have to demonstrate that. You can use a duty of care risk to actually do that. So the risk from excessive request, right? So I can actually demonstrate that it affects my mission. For me to actually perform, those requests, I can show that it was excessive and it actually impacts my mission or my objectives. So you can actually use the risk register to show how things might be excessive or burdensome to the organization.
Unless the Attorney General gives us more guidance to
Unless they give us
specifically
more.
define it. But it's true.
But this is just the way, Jennifer had mentioned. She says, hey, it's going to be up to the judges to determine whether you had reasonable security controls in place or whether you could have reasonably adopted that statute. Was it a burden to you? So the burden's on you to be able to demonstrate that it was a burden. Sorry, double use of burden. But can you demonstrate that it was overly burdensome for that set of controls or statute or meet that excessive request? And that, I think, brings us to questions.
I just want to say one summation. Here's the reality. We deal with clients all the time. Nobody, well, not say nobody. If you're a financial or healthcare institution, you've invested more, you have to invest in this area. It is here to stay. And I know that I'm speaking to the choir for the people in the room, but you have to put effort into it. You have to do data maps. You have to figure out what you're doing with data. You have to figure out some of these risks. And frankly, all of you that are in compliance, legal, or security positions, you have to push that up to your executives because it is a risk-based decision. Organizations we've known for years with cybersecurity, it's not an IT solution, it's a risk-based approach. And your executives need to understand that, whether that's your board or your C-suite, they have to make decisions about this, and they have to understand that where's your company on that risk scale, because that's what judges are looking at through this framework. So it takes work, unfortunately. I hate to be the bearer of bad news, but for all of us that are consumers, this is a good thing long-term to understand what is happening with your data and where it is going and having the ability to control it. So if anybody has any questions, please feel free to ask. We love to talk about them as a group, but we'll be here afterwards as well. And thank you so much.